Hello, good morning, everyone. So, I hope you people are doing good at this moment. And we will be starting with a brand new class of fundamental rights. So, in the last class, we had studied about citizenship and we had already started fundamental rights to some extent. But we will be doing certain extra things. That means we will be just recapitulating what we did in our last class, and with this we will be starting with our today's chapter. Okay, so I hope you people are studying the notes which I have been sending to you guys, so it will be helpful for you, so that because this is being a theory paper, so you need to write down long answers. One more thing, I would like to reiterate the fact that this paper is not your ESP paper. Okay, this is not your ESP paper. This is a different paper. Okay, so we have to study it as a different subject altogether. Okay, so let's move on to the first slide, that is the fundamental rights. If we are talking about fundamental rights enshrined in our part 3 of the constitution and constitutes from article number 12 to article 35. Okay, so if we are talking about this fundamental rights, so this is also can be considered as the Magna Carta of our India's constitution. And next, if we already talked about that there are certain constitutional rights, certain fundamental rights, and you should not confuse between these two things. Okay, so if we are talking about our constitutional rights, that is the right to vote is our constitutional rights, and we have already done certain things regarding ranging from article number 12. So a quick recapitulation of the same, and fundamental rights, and we have already talked about what are the fundamental rights. First of all, we would like to say that yes, the fundamental rights have been inspired from the American Constitution. So if we are talking about we have already learnt about the sources of our constitution. So America's constitution, from America's constitution we have taken fundamental rights. Okay, so, and yes, this is very important thing. You must understand that article number 17 to article 20 and article 17 and article 24, these are, if you're talking about these things, these are absolute rights and they have no restrictions. Else, if we're talking about other things, the other articles, they have certain restrictions in place, and we will talk about all those restrictions in our next class, when we will talk about the various articles. Okay, so yes, some of them are available only to the to all the persons. Okay, so yes, if we're talking about all the persons, it includes citizens, foreigners, and legal persons like corporations and companies. Okay, so these are the things who will be benefited from our this particular fundamental rights if we talk about. Okay, so yes, some are not absolute, but yes, there are certain, they are absolute, but few of the articles are not absolute. Okay, and state can impose reasonable restrictions on them on any given day. Okay, and if we're talking about all the fundamental rights, they are against arbitrary actions of the state. That means if state, where we are talking about, it may be the government, central government, it may be the state government, if they take certain actions against arbitrary actions which can be detrimental for the public of our country, then it is something which we can say that okay, so the fundamental rights can be available at that point of time. But some are available against actions of private individuals as well. Private individuals, I mean, there are certain companies, certain corporations, these are the private individuals. Okay, and even I and you people, if somebody of amongst us goes and impose certain kind of restriction on some person, that will be the time when that person's fundamental rights are being violated, and then there will be certain charges against you, because you are depriving the people from having their fundamental rights. You are not giving them their fundamental rights. And yes, they are justiciable. You can definitely go to the court of law and seek justice if you feel that your fundamental rights are being violated. Okay, so yes, they can be suspended during national emergency, but Article 20 and Article 21 won't be. These are the things which can never be or violate, means they can be never suspended. Okay, Article 19 can only be suspended when there is an emergency on the grounds of war or external aggression, but till now we have not done that. Okay, so right to property, article number 31 was deleted from the Fundamental Act in the 1978 by the Janata government, and it was and by the 44th amendment this was named as a constitutional right. Again, now you see there were certain fundamental rights, and now we again come across this term under Act of 300A in the Indian Constitution. In the part 12 of the Constitution, the right to property has been made our constitutional right. Okay, so constitutional right means that you can have a property, that is your right, but that is not a compulsory right, because many of the people in India does not own a property. They live in rented facilities. So that is the thing which we can say that, okay, if I want to buy a property, I can definitely buy a property because it is my constitutional right. But at the same point of time, if I say that, okay, I don't have a property, but I should get a property because it is my right, that is the time when it is not, as not being your fundamental right, it cannot be guaranteed that you will be given a property. Okay, yes, there are 6 fundamental rights: right to equality, right to freedom, right against exploitation, right to religious freedom, cultural and educational rights, and the rights to constitutional remedies. So today we will talk about right to equality, right to citation, and so today, this being a very interesting chapter, and the same point of time a very in-depth analysis has to be done. So today we will be doing only the first 3 of the India. So right to equality, right to freedom, and right against exploitation. So these are the 3 things which we will do today. In the next class we will talk about the fundamental religious freedom and constitutional remedies we will talk about in our next class. Okay, so let's talk about the Article 12. What the Article 12 deals with? It deals with the definition of state. So what is a state, first of all? So Article 12 basically says that a state has been used in different provisions and concerning to the fundamental rights. And according to it, the state includes the government and legislature of the states, all local authorities, and all other authorities under the control of the government of India. So these can be said as the definition of state. And it's a very interesting thing which we must understand, that once upon a time there was a club in Kolkata, Netaji Cricket Club. Okay, and they had certain issues with BCCI, and that was a time when Netaji Cricket Club said that that the BCCI being a state, they are imposing certain restrictions which is against the fundamental rights being a private individual. And that was the time when the Supreme Court ordered that BCCI should not be considered under the definition of a state, because it does not have any hold on the government. It means the government does not have any kind of stake, any kind of hold in that particular company. So that was the time when the definition of state got refined, and that was the time when it was categorically said that the state includes the government and the parliament, government and the legislature of various states, and local authorities and under the control of government of India. So this was given as the definition of state. So now you can see that this LIC, ONGC, SAIL, etc. These are the authorities, or these are the PSUs which have the government control, and that is the reason why they can also be considered. Now it will say that even a private body or an agency can be, yes, now you see it can come under the instrument of state, but that has certain restrictions and certain things which right now we are not very interested in, because that will be the thing which we will be going into the very depth of it. But yes, sometimes the private individuals are not, just like I said in the time of BCCI, it cannot be said, and it was a time when our state's definition was kind of tweaked, and that was the time when it was said that private individuals can come under it, but there has to be certain restrictions in it. Not every private individual can come under this particular thing. Okay, so now we are talking about the article number 30, and it says definition of laws. So as we are dealing with the constitution, and at the same point of time, we have already seen a lot of times that there are things called laws. Okay, there are laws. What are laws basically? How you have already gone through this particular thing that okay, law, we have so many laws, rules and regulations, but what is a law? So article 13 defines what kind of law that are inconsistent, or it can be used within our power, and which laws under fundamental rights can be said as none. So article number 13, in the territory of India before the commencement of this constitution so far are inconsistent. That means the laws of the British era, laws during the British era, which have not been taken up by our constitution, which stands inconsistent. So those laws, we are not going to follow them anymore. Next, if we are talking about the law, has a connotations, if you can say. Yes, it means it has got a large, wide variety. So permanent laws enacted by the parliament or the state legislatures. There are certain temporary laws like ordinance issued by the president or the state government. So we have got a set of permanent law. We have got a set of temporary laws which after some time won't be given the status of a law. So there are certain executive legislations like certain announcement by the district magistrate, okay, by the DSP of the place. So they also sometimes issue statutory laws. That means for certain period of time, just like you see nowadays, what is a containment zone? What will be the laws followed within the containment zone? These are statutory instruments. They are not ordinance, because that ordinance has not been passed by the president or the governor of the state. Mind it, whenever we need to make a law, we need to have it passed by either state legislature, and it should be given and the state governors in a permanent law or a temporary ordinance. But these kind of situations, when the pandemic situation is going on, and at the same point of time we have certain things like lockdown situation, what is a containment zone, which is a green zone, which is an orange zone, these are the things which are temporary in nature, and it is a statutory instrument because these laws are not being passed by the parliament and also with the order of the state governors. It is the local administrators like the district magistrate, the DSP, they are working on it. So statutory instruments basically is their orders which we need to follow. That means in the containment zone, from this day to a particular day. So this is something which is a temporary provision, and it does not require the from the interference by the president, prime minister, chief minister, or the governors, because it is a very short period of time, and the next when we again go out in so that will be the time when these statutory instruments won't stand any object, they won't be fulfilling any objective when we are, and because that will be the time when we are all free. Okay, so these are the things which we need to understand. Okay, so for the laws, what are statutory instrumental laws? So these are the definitions which are being mentioned in article number 30. So let's talk about the basics of the fundamental rights. As we have already talked about what are the various fundamental rights, just I am going back to this particular slide. So now we will talk about article number 14 to 18, that is right to equality. Okay, so we will talk about this part now. Okay, so right to equality from article number 14 to article 18 has these many provisions. So what are these? Article 14 says it provides equality before laws to all the persons staying in this territory of India. That means all the persons means residents as well as the foreign individuals who are staying over here. So that means they are equal before the law. Now the article 15 says that it prohibits the state from discrimination against any citizens based on anything, that is race, religion, caste, sex, or the place of birth. Religion is also a very important thing nowadays, and as we are talking about, any citizens cannot be discriminated against this. These are the things which they cannot be discriminated. Next we are talking about article 16, and it says it provides equality of opportunity to all the citizens in the matters of public employment. Public employment means we are talking about job given by the government or the state, central or the state, and then all the citizens will be given equal opportunity. Yes, but there are certain restrictions on, there are certain laws and bylaws which we will be studying. Next we are talking about the article 17, which says abolition of untouchability. Abolished, we are not to follow untouchability, and if somebody is found following untouchability, he or she will be dealt with certain punishments as enshrined under article number 17. And article number 18, it says abolition of titles like Maharaja, Rai Bahadur, all these titles which used to be there in the times of the British era, those are abolished. Now we will talk about in-depth analysis of article 14 to article number 18. So now article 14 says equality before law and equal protection of laws. So what does this mean? Actually, article 14 does not deny to any persons or equality before law or equal protection of laws within territory of India. Basically, if you're talking about article number 14, there are certain things which we need to understand. This article 14 has two parts. One part is equality before law, and the second part is equal protection of laws. So these are the two entities of article 14. Okay, so these two things we need to understand. What are these two things first? Okay, so basically, if you talk about, yes, this confers right to all persons, whether citizens and foreigners. I have already said the word person includes legal persons, registered societies, and other types of legal persons. Okay, now I will just tell you one thing about. Let me actually explain equality before law and equal protection of laws. Basically, if we talk about equality before law, it is a kind of a negative statement, and it is some kind of a remnant from the British era. Why this is basically says that about equality, or it says about the negative part? Because it says, means first of all, let us understand the term what equality before law means. It means no man is above law, and every person, whatever be his or her social status, is subject to jurisdiction of the court. That means what? Any person, basically no person is above the law, and whatever is his social status, whether he is an Ambani or a shopkeeper in your locality, everybody is treated equal. Next, if we talk about what is about the rule of equality before law, is actually, if we talk about, this is not sometimes absolute rule. It is not sometimes absolute rule because there are certain restrictions within the Constitution of India. And if we talk about equal protection of laws, okay, before I go to what are the exceptions in equality before law, I would like to explain you equal protection of laws. Equal protection of laws says, and it is a positive concept, mind it is a positive concept, and this is the term which is being some kind of, it can be said as, okay, borrowed from the American Constitution, because American Constitution does not say equality before law, but it says equal protection of laws. And this concept means that all the persons should be treated as equal persons, okay, as alike. If we talk about as alike, means in any situation, any given situation, two persons should be treated alike, whether there should not be any discrimination between groups, between society, and even it makes discriminations or favor, means if we talk about those who are less privileged, they are there, it is some kind of say that, okay, whereas a person is less privileged than someone else, but before law, that person who believes that he is less privileged can feel safe before the law, because he will be treated equally, and he will be protected, his laws or his rights will be protected equally as it is being protected for those who are privileged ones. Now we will talk about what are the exceptions to equality. For President and the Governor of India, there are certain immunities, and these are enshrined in Article number 361. The President and Governor is not answerable to any court, and during the time he is holding his office. No criminal proceedings can be instituted against him, okay, until the time he is in his term of office. He cannot be arrested. The president or the governor cannot be arrested, even if there are certain FIRs being lodged. They will not have any kind of issue. They won't have any kind of effect, because the president and the governor enjoys this immunity, that they won't be arrested when they are in their office. Next, if we talk about, no civil proceedings against the president and the governors can be instituted. Once again, so criminal and civil, both the actions cannot be taken up at this point of time, okay, so they cannot be taken up like means they cannot be answerable to the court of law. And after the expiration of their term, then only they will be treated as a common citizen, and that will be the time when they will be answerable to the court. Okay, so these are the exceptions to the equality. Next, there are certain other things as well. Apart from being the president, there are certain people who also get certain kinds of immunities, like diplomats, ambassadors, and they enjoy immunity from civil and criminal proceedings. The foreign sovereigns who visits India, the rulers, the ambassadors, the diplomats, they enjoy immunity. Like you can say, there were certain people when this happened basically few months back, when the President Donald Trump visited India. There were certain cases filed against him for various reasons, but nobody could, as he came down to India, he cannot be tried under the court of justice. He cannot be tried under the court of justice because he enjoys this protection, being a foreign sovereign. Okay. Next, if let us say that a parliament, in a parliament there is a kind of a vote of confidence or something kind of things going on. Okay, and a person votes in a particular favor of a decision, and his party members or the opposition party members can feel offended and may file a case against that person, that this person has disrupted so and so in the parliamentary during the vote, because his vote was something which could have changed the decision of the parliament, or a law could have been changed. But this is the time when he gets immunity, because whenever he is participating in any kind of voting within the parliament, that is for the country, or that is for the legislature he is representative, and it is about the mandate of the people. So that will be the time he cannot be tried. At this point of time, he cannot be tried in any kind of court, and it will be exceptions to equality, because, and it is a kind of an equalities exceptions, because he is not equally responsible, he is not equally participating in certain decision making of the parliament. Okay. Okay, yes, UNO and its agencies also enjoys certain diplomatic immunity. So UNO, that is United Nations organizations, and their agencies like UNESCO, or we are talking about UNICEF, they also they also get certain immunities. Okay. Okay, so next I will be talking about article number 15, that is prohibition of discrimination on certain grounds. So what are the prohibition or the discriminations on certain grounds? It says that there are basically four parts of article 15. Article 15(1), it says no discrimination on the grounds only of religion, race, sex, or the place of birth, or any of them, and applies exclusively to the matters within the control of the state. So prohibition of discrimination on certain grounds. If you're talking about, it says basically article 15 basically says that the state do not discriminate against a citizen on the grounds only on the basis of these things. Like if you talk about article 15(1), it says about religion, race, sex, place of birth, everything. And if you talk about article number 15(2), it prohibits any discrimination at public places. Like you see, in past, when this untouchability, the caste system was in a prevalent, very highly prevalent. In the villages, there used to be wells, kuma. Okay, so the wells, they were basically demarked for certain communities. That means this is the kuma of the Brahmins, this is the kuma or the well of the other communities. Okay, this is the part where only the Dalits and the lower class communities will go. So these are the things which says about discrimination at public places. And article 15(2) says that these are the things which are not allowed. The state should make sure that these kind of discriminatory practices at public places should be avoided. It should not be done, and it is basically a criminal offense. So this was basically an objective to eradicate the abuse of the Hindu social system, which I just said, and it applies both to state and private individuals. Article number 15(3), protection for women and children. So there are certain laws which has got special mention about the women and children. In article number 15(4), it says the protection of the backward class interests of the backward class, and this was amended in the First Amendment Act of 1951. Okay, that means what? You see in article 15(2), what it says, there should not be any discrimination, and if somebody makes any discrimination, then what will be the laws taking up? So we can see that from here we are leading to article number 15(4), that what if somebody discriminates against the lower class people, then what will happen? Yes, Article 15.4 will be taking place and the interest of the backward class communities will be taken up in this particular act. So now you see that whenever we have certain articles saying about a particular thing, there are provisions for the safeguards of the same in the another subsection of the same article, or in another article it is being submentioned. So this is what we do, that how we are basically, if you see in the first chapter I said that our constitution is a written constitution. It follows a chronology. It does not follow chronology, but it follows logic. It follows chapter wise stuffs. So now you see, now you understand from this article that how Article 15.2 and Article 15.4 are being make a solid law, and whenever we are talking about this thing, we can follow Article 15.2 and Article 15.4 closely and understand what are the implications if somebody imposes certain kind of restriction on the lower class people. And that will be the time when Article 15.4 for discrimination, for exceptions to this general rule of discrimination. Yes, there are certain things. That means if you're talking about article number 50 of discrimination, but there are exceptions once again. You see, whenever we make a law, there will be certain counteractive logics which will say that okay, this if this is happening, then what about other thing? Now you see, as I said, what are the exceptions? The state is permitted to make any special provision for women and children. For example, reservation of seats of women in local bodies or providing free education for children. The state is permitted to make these changes. Okay, reservation of seats in the local bodies for women, because we want active participation of women in making a sound society. So that means if women do not get opportunity to come out of their homes, then how it will happen? And in local bodies, if we talk about, if these women come out because particular area, they can make certain changes. And this is how the importance of women can be emphasized and can be promoted, where the women still do not come out of their houses. Yes, providing free education, that is under our fundamental rights, but still, if you're talking about the other whether the education can be made free of cost, then government can take up, or the state, if it are not state government, the state, which I have already defined what is the definition of a state. It can be a private individual at times under certain circumstances. It can be there. Okay, so that will be the time when if private institutions say that okay, we will give free education for the children in our private schools, that can be done. Okay, next, the state is permitted to make any special provisions for the advancement of socially and educationally backward classes, or for the scheduled caste and scheduled tribes. For example, reservation of seats or free concessions in public educational institutions. That means we are talking about socially and educationally backward class, like scheduled caste, scheduled tribes, other backward communities in India who do not get certain kinds of, those who haven't got any kind of right, they haven't enjoyed their rights. So that will be the time when the state can make certain provisions so that these people from these particular classes can be made to come forward and participate actively in our social life. So this is something which is sometimes we give privilege to those particular people. Okay, and those privileges we will talk about in our next article when we talk about article number 16. But what are the other things? The state can make certain provisions. Okay, the state can make certain provisions, and what are the and advancement of any socially and educationally backward class. Well, I have already talked about this thing. So this is how in the private educational institutions or the government aided institutions or even minority education institutions, these can be make they can have certain kind of reservations and they can study over there. Okay, educational system we are talking about. And if you're talking about economically section, yes, we have recently there has been a category in, if you talk about, there has been a certain category which says about economically weaker sections of the citizens, and for them the government has made a 10% reservation, 10% reservation of seats in education institutions or in job opportunities. So we are talking about this economically weaker sections. They are not necessary that they will be coming from backward classes. No, they are from the higher classes or the general category. Under general category, those who are economically weaker, that means if their annual income is less than 8 lakhs per annum, or they do not hold any kind of land under 4 acres. So 4 acres, or I just don't remember, I can't remember exact the figure, but there are certain categories. If those categories are fulfilled, then that person can claim benefits under economically weaker sections of the citizens. And this will be the time, as we say that prohibition on discrimination on certain grounds, these are the non-discriminatory rules, and these are actually 4 exceptions which we made. And this is something which is done in our 103rd amendment of Indian Constitution. Yes, 103rd amendment of Indian Constitution, 103rd amendment. Okay, so in this 103rd amendment we have given provisions for economically weaker section, and 10% of the seats have been reserved for economically weaker section society of our country. Okay, so now we come to equality of opportunity in public employment, how these things happen. So if you're talking about Article 16, it says no citizen shall on any grounds of religion, caste, sex, descent, place of birth, etc. should be discriminated in any kind of public opportunity or public employment or employment in any office under the state. Okay, so Article 16 says equality before law, before equality for all citizens in this matter, and nobody will be discriminated. There should be certain things, there are certain they should be fulfilling the criteria of that particular office, and if that person fulfills that criteria, he or she can get employment. And it is not like that, okay, a person from advanced class will get more salary, from lower class will get less salary, or there will be certain discriminations, like if he is a Hindu he will get these benefits, if he is a Muslim he will get the other benefits. It is not like that. Everybody is equal and everybody is going to get equal payment, whether he is a male or a female. No discrimination against sex should be made, and this is something which is very, very important. And article number 16 says that the salaries, the perks, the pension, or whatever it is, whatever the benefits we are getting from the office should be same for everyone at same level. Okay, so now there was actually a very interesting case. Okay, it is a case which is also known as the Mandal Commission case, or commonly it is was the common name, but actually it was Indrashawny versus the state. And this was a time when certain things came into effect. Okay, certain things were made into our life. So what were those things? So basically, if we talk about the Mandal Commission, so Mandal Commission was a commission which was formed by the Janata government. Okay, the Morarji Desai was the Prime Minister of India at that point of time, and after 1951, when we had our first amendment and it said about the reserve or protection against the backward class society, Morarji Desai government appointed a second backward class commission under the chairmanship of Mr. B.P. Mandal, and he was a member of parliament, and he made certain provisions, And it was a time this was a actually this was happening at that point of time, and there were certain reservations when the Indra Shawnee case or the Mandal Commission case, when it came into existence, and it actually the Indra Shawnee or the Mandal Commission case occurred sometimes around 1990-91 when the Congress was in power. So it was a nine bench judge of Supreme Court, nine-judge bench of Supreme Court, and it has laid down certain things. Like if we talk about employment, it says that Article 16(4), there will be certain provisions can be made in favor of the backward classes in a matter of employment by executive order also. That means if executive or the government says that there should be certain changes, whether it is state or the center, there can be certain provisions be made. Okay, but the most important thing is the reservation should not exceed the 50% mark. That means if there are 100 seats, there should be minimum 50 seats for the general candidates also. The 50 states means it should not exceed 50 for the reserved category. There should be a permanent statutory body who will be examining the certain things like complaints which are being lodged. At the same point of time, it said that this particular reservation will only be valid during the time they are getting the job, but not while getting promotion. And it is about, we are talking about the other backward classes. This is something which is other backward classes we are talking about. And now then what happened is the scheduled class and scheduled tribes, they enjoy certain rights, but this is the case when the other backward classes also got certain benefits, and 27% of the seats in the government employment were fixed for the OBC categories, the other backward categories. But there was another catch in it. They introduced a term called creamy layer. So what is a creamy layer? Creamy layer is something that is those other backward classes societies or the people, those who have enjoyed certain things in their childhood, at same point of time they are having a income above a certain level, okay, certain level. And this was something which is very interesting thing, that these people won't get the benefit of the OBC reservations, okay, other backward class reservations, because they are rich. Other backward classes, if we are talking about, they are backward class and they want to come in the forefront of the society. So the constitution or the Supreme Court at that point of time categorically said that the people who are rich, those who have got certain financial benefits from the government or from the private individual, whatever they are, they have started to coming up in the strata of the society, and that will with the time. That is the reason why, as their children have already got the benefits of their hard work and they have come forward, so they are not going to get certain provisions under the Mandal Commission case or the OBC category things. I will share a comprehensive note regarding the Mandal Commission and the aftermath of this particular thing, where this reservation of 27% of the OBC candidates were taken up. So I will be giving you a detailed write-up in your Google Classroom. Okay, so let's move on to the next slide. The article number 17, which says the abolition of untouchability. It says that Article 17, it forbids any form of practice of untouchability. But if you're talking about untouchability, untouchability is a term which was not defined by Supreme Court at the time when the Article 17 was made. So there was an interesting thing where the Mysore High Court said in this particular subject that what is an untouchability, or what is the definition of untouchability. So Mysore High Court said that untouchability is, in its literal sense, Article 17 is not about the literal sense of untouchability, but it is a practice which has developed or which had developed historically in this country. It refers to the social disabilities also, which are imposed on certain classes of people because the reason of their birth. So these are the discriminatory practices which should be abolished, which should not be encouraged, and this will be an offense which is punishable in accordance with law. Okay. So in actually 1976, the Untouchability Offence Act 55 was comprehensively amended and renamed as Protection of Civil Rights Act 1955, so that it enlarges the scope and make penal provisions more stringent, because it is not about untouchability. It is about mental harassment. It is about social stigma, which affects the people or the persons who face these kind of problems in day-to-day life. So that was the time. That is the reason why it is known as Protection of Civil Rights Act. It is not only about untouchability, but for our benefit or for our memory purpose, we can definitely say that okay, it is untouchability, but it also has a large scope. Not only untouchability, but the social stigma related to untouchability. That has also to be taken into consideration. And it says categorically, if we are talking about the protection of civil rights cases, it categorically says is that this act will this particular these following acts, which can be taken up as a cognizable offense and punishable according to the law. And what are they? I'm just naming few. If you are preventing any person from entering a temple because of his lower caste, you are bound to be punished by law if a case is being filed against you. If you try to justify untouchability as a traditional religious practice, then you can be tried in court of law and you will be punished for this offense. You cannot deny access to various kinds of, I said about wells, but we can also say the same thing about shops, hotels, restaurants, that these people cannot enter, because at times we can say there has been certain times that few people were denied entry to a hotel or restaurant because of their dressing pattern, dressing sense, because they may not be wearing proper clothing. They may not be because other guests inside the hotel can feel weird because of presence of someone who is not at their class. That means what? You are again creating a social stigma. That can also be acted, that can be also said as a cognizable offense. Next, if you're talking about if you are insulting any lower class people, that is also a very, very bad thing, and that can also, if possible, that if not possible, means it is actually can be punishable according to the law. You cannot deny entry even in hospitals as well, because okay, this person is from lower class, no, I won't, he cannot pay for the bills. No, it's not like that. You have to take it up. But yes, at sometimes we see a lot of cases coming up in the hospitals as well. But yes, the places for the public benefits, that has to be taken care, and there on those and in those places we cannot just deny anyone of their fundamental rights. Okay, we cannot say that okay, I am not going to sell my goods to that person because he is from that community. That also cannot be done. That is also a punishable offense. So these are the things, means you see now I said about abolition of untouchability, but it has actually got a large scope. It has got a huge scope, and that is the reason why we are seeing it as our civil rights, and Protection of Civil Rights Act can justify Article 17 in a very broad manner. Let's talk about the next article, that is Article 18, which says abolition of titles. Abolition of titles are actually under 4 provisions basically. You see that no title, being a military or academic distinctions, shall be conferred by a state to any citizen, whether to anybody, whether it's a citizen or a foreigner. We cannot give them any title. But yes, if it is a military or an academic distinctions like PhD, when a person gets his PhD or a person passes his MBBS, they add doctor to the prefix of their name. That can be done because it is purely academic. If you are typing captain, you are writing lieutenant, if you are writing colonel, or if you are writing major general, that are military titles and that can be conferred to a person. But other than military or academic distinction, if we say that let me confer him a title of Rai Bahadur, which the British era used to do. So those, or Maharaja or Raja Dhiraj, that these are the titles which distincts that a person from the other people of the society. These cannot be given, and it is about whether citizen or a foreigner, we cannot confer. And at the same point of time, we prohibit any citizen of India from accepting anything from foreign state. We like this, if it is not an academic distinction, we prohibit, our constitution prohibits the citizens of India from accepting any titles from the foreign state. A foreigner holding any office of profit or trust under the